right. It is now my pleasure to introduce Maureen Weaver, partner at Wiggin and Dana and the longtime legal consultant for Leading Age Connecticut. Maureen will lead today's presentation of the 2022 legislative outcomes relevant to aging services and senior housing. Maureen is here with her colleagues, Jermaine Brookshire and Carolyn Park, and we thank all of them for the tremendous amount of work that went into both the summary document and today's presentation. So Maureen, the floor is yours.
Thank you very much, Meg, and good afternoon, everyone. It's a pleasure to be here to present the 2022 legislative summary. Shout out to my colleagues for joining me here today. Jermaine Brookshire is an associate in our corporate department in our healthcare practice, and Jermaine deserves tons of credit because he led a group of 6 of our law student summer interns, we call them summer associates, who took it upon themselves to coordinate and produce the document that we've shared with you, summarizing all of the key laws that were enacted during the 2022 legislative session. And
oops, Maureen, I think you froze.
I'm the only one here.
Dave?
Yeah?
Can you hear me?
Oh, I can, yeah.
Okay.
Hi.
Hi, but I think Maureen froze.
oh,
Oh, there
can
you
you
are,
hear
Maureen.
me?
Now I can hear you.
Oh, I'm sorry. I'm getting a signal saying my internet connection is unstable and I'm sitting in the office. Can you hear me now?
We can hear you. Maybe if you turn off your video, that might be helpful. Sometimes that helps.
Oh, okay. Stop video. There we go. Maybe that'll help.
We'll hear your voice, Maureen.
Yeah, just let me know if there's a problem.
Okay, we can hear you clearly now.
Okay, great. All right. So here's our agenda for today. We're going to review the 2022 legislation. I'm going to kick it off with a review of key laws and action steps required for the provisions that really affect you at the core, the regulatory provisions that affect you at the core for long-term care services. Caroline's going to follow up with a review of key employment laws, and then Jermaine's going to cover other laws that are of interest. We are not following the order of our legislative summary, but we are referencing the legislative summary on each slide. So if you wanted to go back and get more details or even get a link to the actual public act, you'll see a little reference to LS and then a page number, and that's what that refers to. We're going to spend about an hour maybe on the legislative summary review, and then following that, I'm going to give a presentation that'll last 45 minutes or so, providing you with a roadmap on the CON process. A couple of housekeeping matters. Meg mentioned that you have your materials and your slides there, and then also at the end of each section, we'll stop and pause and see if there's any questions in the chat. So moving right along with our key laws and action steps. I just want to comment that it was quite a busy legislative session, even though it was a very short one. And it was largely successful because Leading Age was able to improve some laws that have been enacted previously that had some iffy provisions that needed a lot of clarification. And as you'll see in the latter part of this presentation, we were able to make some significant reforms and improvement in the CON laws. Now, one thing I do want to note, some of you may have heard a presentation that I gave at the June 14th Leading Age board meeting where I reviewed laws that took effect on July 1st and action steps that need to be taken to get into compliance. I'm going to go back over those again because I'm assuming that some of you may not have attended that session. But you know, for those of you who did, I think it's a good refresher just to sort of look at the checklist and make sure that you've gone through all of those steps to make sure you're in compliance. So this first provision is really just a rundown, a quick rundown of the key budget provisions that affected aging services. We had our 4.5% increase in wages and full funding for the acuity system for the fiscal year 2023. And I pause there and emphasize it's only for the fiscal year 2023, even though we're seeing acuity rate projections for years following this. There's going to be need to be new appropriations in the session that starts for the budget year 2024 and beyond. RCHs received 1 year of rate relief using the $3.7 million in the American Rescue Plan Act funding. More $3 million in ARPA funding for adult day centers and Meals on Wheels. We also saw that the home and community-based services, there was a provision implementing and making permanent prior ARPA funding increases. And then another budget item was the Connecticut Home Care for the Elders. The state-funded portion of the copay was actually reduced from 4.5% to 3%. So starting out with our rundown of key provisions here, the first one I want to review has to do with reporting abuse, neglect, mistreatment, and those sorts of things affecting an elderly person to the Department of Social Services. This is the statute, we call it the Elder Abuse Reporting Statutes that's been on the books for many years. And as you know, it obligates individuals, not licensed healthcare entities, but individuals such as nurses, doctors, pharmacists, dentists, administrators, anyone employed in a long-term care facility, such as a nursing home, residential care home, or in home care or adult daycare, to make reports when they have reasonable cause to suspect or believe that abuse, neglect, exploitation, abandonment has occurred to an elderly person. And it used to be, it's been on the books up until the effective date here, July 1st of 2022, that you had 72 hours to decide whether or not you were going to make these reports. 72 hours was actually a healthy amount of time, because I think the drill everybody runs through, especially in a nursing home situation, when you receive an allegation of abuse, is that you immediately, if it's abuse or serious injury, you have to report it right away within 2 hours to DPH. And if it's not abuse, but it's any other type of neglect or misappropriation, you have to report it in 24 hours. And then you do your investigation, and then you have some time to decide whether or not to report it to, Elderly Protective Services at DSS, depending on the outcome of the investigation. Well, your time frame has now been shortened from 72 hours to 24 hours. So you're going to have to make those assessments within 24 hours. Now, it's interesting because there's a separate statute that deals with reports of these kinds of elderly abuse situations that occur in long-term care facilities. And the 72 hours wasn't changed in that statute, but it references this one and the DSS Elderly Protective Services process. So my advice is that you just assume that you have 24 hours to make that determination about whether to make the DSS report. And I note that rarely enforced that I've seen, but there is a $500 fine for individuals who fail to report. And if it's really egregious, it could rise up to a criminal misdemeanor. So it is something to take seriously. Now, in terms of action steps, I think it's really important that everyone take a look at your abuse and neglect reporting policies and procedures, and make sure that you've revised the 72 hours to 24 hours for the reports to Elderly Protective Services. Make sure your staff are trained and are aware of this change. So a lot of times these incidents occur over the weekend, and the weekend staff don't necessarily, aren't as clued in as other staff on these types of things. And note that compliance with these state timeframes is also reviewed during federal surveys. So our next provision that took effect on July 1st for nursing homes, takes effect on November 23rd, sort of an odd, funny date for residential care homes, is that any notices of transfers or discharges have to be, that, as you know, in each case, the ombudsman needs to be copied on notices of transfers and discharges that are provided to residents. And now for nursing homes, effective July 1st, and for residential care homes in November, these have to be uploaded through a special portal to the ombudsman's office. She has an electronic reporting system. It's already up and running for nursing homes. However, I spoke with her by email just last week, and they're still working on the RCH portal, but they do have time to get it in place. And in terms of action steps, here's the link for nursing homes to the nursing home portal. As I said, the RCH portal should be up by the time the effective date comes into play. But you should take this as an opportunity to revise your policies and procedures to include this electronic reporting process. make sure you take a look at your model forms. I shudder sometimes when I see model forms for transfer and discharge because you all don't use them very often. And sometimes I even see the old DSS address or the old ombudsman address over on Sigourney Street. So it's important to update and make sure that those forms are in good shape and also that your staff are aware. So speaking of transfer and discharge, we have a major project that Meg and I and others participated in for many years that finally concluded this year with the enactment of this provision. This is part of the massive Department of Public Health bill that turned into a public act and codified a whole bunch of different revisions to public health related statutes. And this one amends the residential care home transfer discharge statute to align it more with the CMS home and community-based settings requirements so that Medicaid will pay for home and community-based settings services provided in RCHs. There was an issue before in that some of you know the settings rule provided that, you know, if you have a home and community-based service that's provided that is on the campus of a healthcare institution or facility, then that wouldn't be considered in the community. So the effort here was to take a look at all aspects of residential care homes, for example, including how folks are dealt with in terms of their agreements and transfer and discharge to make sure that those provisions are more like how people are treated in the community. For example, under landlord-tenant law like provisions where you have plenty of notice and you have an opportunity to contest any attempt to ask you to leave the facility. So Leading Age participated in the task force that developed these revisions. I'm going to go through the changes very quickly here. But the first is that the notice must state that the resident has the right to represent themselves or be represented by counsel, and it has to contain contact information for both the long-term care ombudsman and Disability Rights Connecticut, which is the disability rights advocacy organization. It also has to be sent electronically, as we mentioned before. There are also rules that were expanded for emergency transfers and discharges so that there can be an emergency discharge when the resident poses a threat to their safety, safety of other residents, or safety of facility personnel. The residential care home can request an expedited decision from DPH in those circumstances. I don't think this is something that affects most Leading Age members, but it was a real concern for some of the other like smaller owner operated residential care homes with sort of a younger population. And the ombudsman was particularly interested in making sure that this was an appropriate provision. Also, under current law, residential care homes are required to help people find a relocation spot if they were asked them to leave. Now they're required to actually provide discharge plans within 7 days of providing the notice. The resident also has a right to appeal. That's always been the case. Within 10 days, DPH has to hold a hearing within 7 days, and then they have to issue a decision within 20 days. It's a little bit more of a compressed time frame than before. And the big new requirement is that before, there was no ability to appeal a DPH decision to Superior Court, and now there is. And that was something that was advocated very strongly by legal services. They were involved in the task force. They actually, excuse me, they were actually advocating that these provisions basically refer to or mirror landlord-tenant law, and we kind of pushed back on that. And this was something that came out of the compromise at the end of the day. So in terms of action steps, it's really a rare occurrence that I think for most of our RCH members that you're going to run into these situations. So if you do, it's really important that you review the statute very carefully. And you also might consider checking with counsel before you start any involuntary discharge process, whether it's in the residential care home setting or in the nursing home setting, because there are a lot of pitfalls involved. And just making sure that your notice complies with the applicable requirements. So the next set of laws I'm going to cover are provisions where in 2021, there were enactments made, kind of quickly at the end of the session. They weren't the greatest drafted provisions. They left a lot of questions up in the air, and this is a prime offender, the social worker staffing provision. So in 2021, the General Assembly enacted a law, as you know, requiring the DPH establish minimum direct care staffing levels in nursing homes of 3 hours of direct care per resident per day. And part of that enactment stated that nursing homes should employ one full-time social worker for 60 residents. And then it stopped. It didn't say anything about, well, what happens if you have fewer than 60 or a lot more than 60, or does it mean that you always have to have a full-time social worker? It was really vague. And so Leading Age very appropriately raised this as an issue with DPH, and in the process, the legislative process, we worked out a solution here to amend the 2021 requirement of one social worker to 60 residents by clarifying that it's going to be applied proportionally based on the number of residents in the nursing home. So that's important. It's the number of residents, not the number of licensed beds. DPH was charged with issuing regulations in 2021 on the minimum staffing requirements for direct care as well as social worker. And by the way, there was also a staffing requirement for therapeutic recreation, but they never got around to that. And so this act also allows DPH to issue policies and procedures that are supposed to take effect before the regulations are finalized. DPH has yet to issue the policies and procedures on the proportional application of the staffing requirements for social workers. They did share a draft with Leading Age and CAHCF just yesterday, and we're in the process of reviewing it. So hopefully we'll have some input into all of that and be able to, it'll be shared with you at some point soon. So action steps is adjusting social worker staffing proportionate to the number of residents. Once we have guidance from DPH, that hasn't come yet. Even though this law took effect back in May, they're really short staffed up there. So I don't think they had a chance to get around to this right away. So in a similar vein, there was another refinement to the 2021 legislation, and here affecting the infection prevention and control specialist. So this affects nursing homes and assisted living dementia special care units, both nursing homes and assisted living only dementia special care units. And in 2021, the legislation simply stated that each nursing home and dementia special care unit had to employ a full-time infection prevention and control specialist. And this is really not tenable for most, and so many of the, particularly the dementia special care units, are very small. And so there was clearly a need, and DPH agreed with that, for some clarification on that. And so as a result, the 2022 revisions amend the requirements to provide that only facilities with more than 60 residents must employ a full-time infection prevention control specialist. Facilities with 60 or fewer may employ them part-time. Now, what does part-time mean and what does full-time mean? Once again, DPH was supposed to come up with policies and procedures, or actually they weren't supposed to come up with policies and procedures here. I take that back, but I believe that they are going to incorporate some guidance on those policies and procedures that they're putting together for the social work staffing and the direct care staffing. So this law also created an exception for situations where we have nursing homes or dementia special care units that are co-located. You could, or nursing homes that are co-located on the same campus as another nursing home. And I think we might have maybe one situation like that in the state. So you can allow there to be one infection control specialist covering both of those areas if you apply to DPH and obtain their approval. The hitch is that the two units or the two nursing homes have to be adjacently located or on the same campus, and they have to be under common ownership and control. And DPH is supposed to issue some kind of direction as to what sort of form you're supposed to submit or what the process is for submitting to get that approval. We have yet to see that. We didn't even see it in these these draft policies that were shared with us yesterday. The other important aspect of this law is that you might recall that there was a provision in the 2021 law that said that the infection prevention and control specialist had to kind of vaguely arrange for or cover all 3 shifts, and everyone was concerned that that's physically impossible to cover all 3 shifts. And it's even challenging if you interpret it in a reasonable way to say that during some period of time you would cover all 3 shifts. So that's been clarified to state that instead there needs to be procedures implemented to monitor infection prevention and control practices on all 3 shifts. Then finally, the law, and this is also very helpful and will provide for some additional flexibility. It does give DPH waiver authority for these requirements. So you have, some clarification, part-time, not just full-time. You have a provision for these co-location situations, and then you also have the opportunity to apply for a waiver. In terms of action steps here, again, you can target this law took effect on July 1st. I don't know whether some people have gone ahead and made some adjustments to their staffing on that basis, but you might want to wait until these DPH policies are finalized. We expect that will happen very soon. You do need DPH approval if you want the infection prevention and control specialist to cover 2 nursing homes or nursing homes and dementia special care units that are adjacent or on the same campus. It's going to be important that to address this issue of having procedures in place to cover all 3 shifts, my advice would be that you document those procedures, because I'm sure that they're going to be reviewed upon survey to make sure that you have that procedure in place. Speaking of infection control, a small provision I just wanted to bring to your attention took effect in May. And that is that nursing home administrators are now required to have continuing education on infection prevention and control. It's a mandatory topic for CEUs or for CEs. And fortunately, though, there's no change. They didn't increase the total number. It's still a 40-hour requirement every 2 years. Another provision that took effect on July 1st that had that leading age really facilitated happening very early on in the session, and even before the session, the groundwork was laid for this, and that is revisions to statutes governing managed residential communities and ALSAs to provide for more flexibility for our HUD assisted living conversion program providers. And under this public act, or this provision of the public act, it now permits but doesn't require that assisted living services be provided by an ALSA for the HUD assisted living conversion programs. So they now have the option. If they want to use an ALSA, they can. As many people know, there's been a shortage of ALSAs that are able to provide services in this setting. So now with this additional flexibility, they could also arrange for assisted living services through the Connecticut Home Care Program for the Elders or other means. The other loosening up of the requirements is that the assisted living conversion program housing is exempted from having to register as a managed residential community. But if they desire to register as a managed residential community, they may do so. So the action step here is really for those providers that are affected to review your current structure and figure out what the best option is for your organization. So next we have a provision that was enacted. It was actually enacted in the big budget bill 22-118. And this is a continuation of efforts to impose consumer protections in the home health and home care settings. Both licensed home health care agencies and homemaker companion agencies are affected here. And it kind of is a follow-on to a law that was enacted in 2019 that prohibited non-compete provisions in home health care and homemaker companion agency contracts with their employees and contractors. So those contracts were those types of provisions, the non-compete clauses, were deemed to be void and against public policy and prohibited. And so now the focus and attention was on contracts that these agencies have with clients, where there might be restrictions on clients hiring their employees. And so there's now a provision on the books, it's in effect now, that applies to both the licensed home care agency as well as the homemaker companion agencies that are registered with the Department of Consumer Protection. It prohibits no hire clauses that penalize clients for directly hiring an agency employee or that deems them to be in breach of contract if they do so, and also deems any no hire clauses to be void and against public policy. And so what that means is that if any contracts going forward really should not contain these no hire provisions. And if you have contracts that are already in effect, just know that they can't be enforced. They're going to be deemed null and void. So, here are the action steps here, kind of repeating what I just said. Just reviewing your contracts and forms to ensure in the future these clauses are not included, and be aware that they can't be enforced. Now, we also have had a couple of our Connie electronic health record system for the state of Connecticut popped up in this legislative session. And I think many of you are very aware of Connie because we've made some presentations with the folks from Connie, and they are now reaching out to the nursing home sector as well as home and community-based services providers to start getting on board to the state's electronic health record system. And there's a requirement that's in statute right now, and it's still in full force and effect, that for nursing homes and other types of providers other than hospitals who have an electronic health record system that's capable of connecting to and participating in Connie, that they must start applying now and begin the process of connecting to and participating in Connie, or they must apply by next year to start that process. And I think many of you are starting to get onboarded by the Connie folks in that regard. The purpose of this particular provision was to give the executive director of the Office of Health Strategy the authority to adopt regulations and interim policies and procedures to make all of that happen. There's a lot of detail. The statute the statute was very broad, and there's a lot of detail involved in these procedures and steps. And I think that's what they're anticipating that they'll put into regulations for this particular provision. We have another interesting law that was enacted. We didn't cover this back in June because it really doesn't take effect until January 1st. And this is a classic case of a state legislator who had a passion for a particular issue. And his passion is that he's very concerned about wanting to make medical equipment accessible for disabled individuals. And he really wanted originally to have a bill passed that would have required that all healthcare facilities comply with these federal standards. They're called the architectural, they're standards created by the Architectural and Transportation Barriers Compliance Board, which is a federal agency that ensures federally funded facilities are accessible for individuals with disabilities. My understanding is that these standards aren't sort of legally required yet, but they're standards that people can follow. And so rather than getting a law enacted that would have required that all healthcare facilities follow them, we were able to influence the legislature to simply require that facilities consider the standards when they're looking to purchase this equipment. Now, the definition of healthcare facilities is very broad. It applies to nursing homes, residential care homes, hospice facilities, and all types of other healthcare facilities purchasing medical diagnostic equipment. The definition of medical diagnostic equipment, however, is pretty specific. It refers to examination tables, examination chairs, weight scales, mammography equipment, x-rays, imaging, and other radiological diagnostic equipment. So it may not affect you in every way, but there could be, you may have some touch with this, and just be aware that you'll need to know about this requirement starting January 1st. And, as I said, the goal is really to ensure that medical diagnostic equipment's accessible, the main action step is if you're purchasing anything that's considered medical diagnostic equipment, you might want to document the steps that you took to consider the board standards. Another provision in the law is that DPH is required to notify each healthcare facility, physician, APRN, and physician assistant of quote unquote relevant information about providing services to individuals with disabilities, including these special standards by December 1st of 2022. So you might be getting, if you get a communication from DPH about this, you'll know that that's what it concerns. Just a couple more things before we open it up for some initial questions. The first is that we now have a community ombudsman in Connecticut effective, the law took effect on July 1st, and the community ombudsman is supposed to be appointed by our current long-term care ombudsman by October 1st. And it's sort of a weird enactment because it started out being enacted in the budget, the big budget bill 22-118. And then there was another bill that was enacted into law, Public Act 22-146, that sort of repeats everything in the budget bill and makes a modification, but it doesn't say that it's replacing the budget provision. It's very odd. But anyway, the community ombudsman is really supposed to be focusing on advocating for individuals who receive long-term services and supports in the home and community-based programs administered by DSS. So it's not a far-reaching home and community-based services ombudsman. It's really focused on the HCBS programs administered by DSS. And so it applies to services provided by home health care agencies, hospice agencies, and homemaker companion agencies. And the whole purpose, as stated in the law, is to have this individual assigned to identify, investigate, refer, and resolve complaints, which is typically what the ombudsman does, but there's also added responsibilities to foster public awareness of home care, provide coaching and self-advocacy, and provide referrals to home care clients for legal, housing, and social services. Now, the community ombudsman, there are some very strict provisions that the community ombudsman may only have access to data about a client with that client's written consent or the consent of the authorized representative. There is an exception for the types of situations that are serious that might need immediate investigation, where the community ombudsman can have access if the client can't consent or there's no authorized representative. The original appropriation / budget bill provided for the community ombudsman to be able to hire a bunch of regional community ombudsmen, but that was taken away. So the authorization, as I understand it, is simply for this one individual to serve as a community ombudsman. So the last item I want to cover is the changes to the CON laws. We're going to delve into this very deeply when I present on the roadmap for the CON process. But just in case some of you can't stay for that additional presentation in the hour, just hit the highlights here. And this is really a credit to Mag and our lobbyist, Hillary Felton Reed, to get all of these provisions enacted into law after a lot of negotiating with DSS. It affects nursing homes and residential care homes and the CON process. And the revisions include more opportunities for having informal conference discussions with DSS about pending CON applications, a new small house moratorium exception to the CON, the moratorium on new nursing home beds, and lots of provisions referencing the small house model, which I believe is something that the current commissioner highly favors, and then more clarifications for replacement facilities. So there's no immediate action steps here, but you just need to be aware that there are these provisions in the law, and some of them are helpful, especially if you're going to embark on the CON process. And again, we'll have more details on this later. So I want to pause right now and just see if there are any questions that people have they want to raise about anything I've covered so far, or any questions in the chat.
All right, I don't see any questions in the chat, but does anybody have a question? You can just unmute yourself. All right, I guess there's no additional questions, Maureen.
Then I am going to turn this over to Caroline Park, and she's going to update us on new employment laws.
Thank you, Maureen. I appreciate it. Hi, everybody. I've had the opportunity to speak with some of you in connection with some employment laws. We'll talk about different ones today than we've had an opportunity to discuss thus far. I'd like to start with Public Act 2224, which is known, of course, as the Captive Audience Law. Thank you. I'm sorry, I didn't know who was advancing slides, so thank you for moving it. So this is one that probably did not sneak by under the radar because there was a lot of coverage and discussion about it. This is, of course, the act protecting employee freedom of speech and conscience. There have been many proposals over the years for legislation regarding these types of meetings. And for the very first time, of course, this year, that legislation was successful. So this prohibits employers from mandating that employees attend meetings, listen to speech, or view communications, the primary purpose of which is to communicate the employer's opinion concerning religious or political matters. So while it's really quite sweeping, the environment in which this usually comes up in is, of course, a union campaign when an employer may wish to hold a meeting with its employees to communicate the employer's view on the union, which is lawful right now. More on that in a minute. Under the federal law that regulates labor relations in the private sector, the National Labor Relations Act. But this law is really seeking, as broad as this language sounds, that's really at the core of what type of employer behavior they are seeking to eradicate. Religious matters is defined pretty broadly, any matters relating to religious affiliation and practice and the decision to join or support any religious organization or association. Political matters includes matters relating to elections for political office, political parties, proposals to change legislation, proposals to change regulation, and the decision to join or support any political party or political, civic, community, fraternal, or, of course, labor organization. If we could go to the next slide. Oh, I'm sorry. I thought I had a slide with the exclusions. I want to walk through what's excluded from it. One category is communicating information to employees as required by law. So you are, of course, free to continue holding mandatory meetings to convey information to employees that you have to share with them, even if they would otherwise fall within, say, political matters, because you're talking about a change in legislation or a change in regulations. There's likewise an exemption for communicating information to employees that is necessary for them to perform their job. This doesn't cover institutions of higher education if things have to do with academia or coursework. This also does not cover casual conversations between employees and employers, so long as participation is not required. So if these are discussions that can be fraught for other reasons, but this is not intended to capture, water cooler conversation about religious, religion or politics. This is about mandated meetings. So most significantly, I would say for healthcare entities, the law is going to prevent employers from holding mandatory meetings or distributing unsolicited communications for the purpose of educating the workforce about the decision to join a labor union. Really do expect to see some litigation about this public act because it's widely believed this is entirely preempted by the National Labor Relations Act, which is a federal law. However, the current composition of the National Labor Relations Board and its current general counsel has indicated that the NLRB too intends to revisit the NLRB's rules regarding captive audience meetings. Again, under current NLRB law, employees are permitted to hold captive audience meetings on basically right up on the eve of a union election. But the current general counsel is inclined to limit that and restrict an employer's ability to hold that. So while we do believe there's a significant preemption issue here under federal law, we may see a change in federal law too that would restrict an employer's ability to communicate directly on a mandatory basis with their employees during the union campaign. Next slide, please. All right, so Connecticut Public Act 22-118, you might have heard this on the news today. This program recently launched, but the payroll portal crashed. And I heard this morning that they anticipated that the portal would be back open tomorrow. Again, that portal is where eligible applicants can submit to receive the premium pay program. These are the bonuses for essential workers who worked during the pandemic. There is a sliding scale of eligible payments based on income range. The table is in the legislative summary at page 4. So this is not for employers to submit. Employees can do this directly, but it's something you may field questions about and wanted to be sure to include it. So you may see more news about it. Hopefully the portal is up and running again tomorrow, as announced this morning, so that employees can get their applications in for this COVID relief premium pay. In a similar vein, if we could go to the next slide, there was also this slide. Yeah, there was also an expansion of the Essential Workers COVID-19 Assistance Fund. This again offers assistance to affected persons, and that's defined to include essential employees who may have passed away and their estate is seeking it, or who were unable to work due to a confirmed case of COVID-19 from March 2020 through July 2021. There were some adjustments made to this program in this most recent legislative session, basically extending the deadline to apply now through the end of the calendar year, slightly increasing the categories of persons who might be eligible to participate and receive the assistance funds as an essential employee, and then shifting around how some of the offsets might have worked for employees who had some form of paid leave from their employer or who received unemployment benefits or disability benefits during that time. So we're seeing some slight shifts in how those offsets might work in determining the amount of money somebody might receive if they're eligible for funds through the COVID-19 Assistance Fund for essential workers. Next slide, please. This is an important addition. There's a Connecticut statute, as you may know, regarding strike contingency plans for healthcare institutions. There are updates here requiring really greater degree of specificity in strike contingency plans. Before this revision, the statute didn't really have anything in the way of specifics about what the contents of a strike contingency plan might contain, but we now know that it needs to contain, at a minimum, staffing plans for at least the first 3 days of a strike, and the names and titles of individuals who will be providing services at the institution throughout the strike. So again, that's much more specific than this prior statutory language. Next statute I just want to touch on is not something that will change your day-to-day, but something to be aware of, is an expansion of the anti-retaliation provision in Connecticut's Family and Medical Leave Act. Probably all know since January 1, 2022, paid family leave has been available to Connecticut employees who are otherwise eligible. That basically runs parallel with the Connecticut Family and Medical Leave Act, with the Connecticut Family and Medical Leave Act providing unpaid job protected leave, and that is something administered by the employer. And the Connecticut Paid Family Leave Act is providing wage replacement income benefits during that leave, and that is administered by the Paid Leave Authority. So the anti-retaliation provision is now just a bit broader, such that protected activity is no longer just applying with your employer for the job protected FMLA leave. It also now includes applying to the authority for paid leave benefits. They're almost one and the same. You're really not going to have a situation where someone is protected based on an application for paid family leave and not for FMLA, because the employee would have sought job protected leave as well. But as always, an important reminder, FMLA retaliation cases can be quite difficult to navigate. So it's always good to bear in mind how strong those anti-retaliation provisions are. All right, and this is the last employment law we'll touch on quickly, which is nothing concrete yet, but a really hopefully exciting initiative to address the pipeline of future workers. So this is going to establish a collaborative initiative to address the healthcare shortage in the long term. So we should see some collaboration among various departments and committees to make recommendations in the next couple of years regarding ways to increase the healthcare workforce in the state of Connecticut to address this shortage. There's some more specifics there on the slide about some of the topics that are going to be within that task force purview, and how the chief workforce officer anticipates collaboration with members of the CHA, community-based professional nursing associations, and nursing home and assisted living associations. So at some point, I guess, before January, some of you may be involved with the chief workforce officer in finding ways to make recommendations through that task force. Any questions about the employment laws that we covered? I know we went quickly, but other than the big news that the captive audience legislation that got kicked around for so long finally passed, wasn't too much in terms of specific employment concerns this legislative session.
Carolyn, I don't see any questions in the chat. Does anybody have a question? You can unmute or place the question in the chat. All right, then. Thank you, Carolyn.
Great.
Great.
Thanks, Meg.
Thank you, Caroline. So with that, we'll turn it over to Jermaine to cover some other new laws of interest for everyone.
Yes, thank you. Slide.
Oh, for some reason, oh, there we go. There you go. And so we'll start with your first.
Well, first up is this is a provision within the budget bill, which basically just increased the community spouse protected amount to $50,000. This section required the commissioner to also issue a report, which is due on July 1st, 2023. And this report is going to be required to cover the number of community spouses able to keep those additional assets because of the increase in the amount, and the cost to the state of increasing the minimum community spouse resource amount. Next is PA 22-121, and this concerns the study of the cost and feasibility of permitting the community spouse of an institutionalized Medicaid recipient to retain those maximum amounts. Yeah, with here, just basically DSS is required to produce this feasibility study by July 1st of 2023.
I haven't confirmed it yet with Bernadette, but I have a message into her.
Slide, please.
Perfect.
Here, this provision of this act is concerning the long-term care Medicaid application assistance. Here, DSS is being required to develop an advisory for medical assistance applicants for long-term medical care and home care regarding their right to receive such assistance. What's important to note here is that the advisory must state that applicants are not required to hire an attorney, but that obtaining legal advice before completing the application may help protect their finances and rights. And you'll see that, you know, this advisory should have been posted by July 1st of this year on DSS website. And those applications are going to be available until September 1st of 2023. Next slide. So this one was kind of exciting, the Connecticut Data Privacy Act. This is scheduled to take effect on July 1st, 2023. And one thing I will say is that this largely aligns with Virginia, Colorado, and Utah, but you'll see that it deviates from California by excluding a private right of action and providing an entity level exemption for businesses that are regulated by Gramm-Leach-Bliley Act, which concerns financial institutions, and HIPAA. What's important to note here is that businesses that already comply with the state privacy laws, such as HIPAA, should be well positioned for compliance with the new Connecticut Privacy Act, including its requirements to obtain freely given, specific, informed, and unambiguous consent to process certain sensitive personal information and prepare data privacy assessments for certain processing. But again, it's very an exhaustive updates, and we provide a much more detailed list of those certain exemptions and such within inside the summary. Next slide. So PA 2281 really builds upon what was done last year to provide greater flexibility in telehealth during COVID, and it's extending those provisions until June 30th, 2024. I think one of the noteworthy things here is that it amends the permanent telehealth statute that will apply starting July 1, 2024, to permit those licensed certified providers from out of state to provide mental health or behavioral health care through telehealth in those certain circumstances. So again, it's just allowing for that flexibility to continue on for a longer period. Next slide. So property tax exemption. Here, what's important to note here is that they provided flexibility in the sense that certain housing that was just required to be temporary, they're now allowing for those permanent housings to be eligible here. And so the property tax exemption applies for certain properties such as orphanages, housings for persons who are homeless, persons with mental health disorder, or short-term housing with an average length of stay is less than 6 months. I think also something important to note here is that the new exemption applies for assessment years starting October 1, 2022, not past assessment years. So it's best here to seek advice on how to benefit from the exemption if you think it applies, or for any other property tax issues, since some towns recently have been aggressive in challenging prior exemptions. Next slide, please. So Section 62 of this act requires the Commissioner of DPH to convene the Legionella Working Group. This group consists of representatives from hospitals, nursing homes, and water companies. And it requires the Commissioner to convene this group. This group is supposed to be convened by July 1st of this year to produce a report that's due on December 31st, 2022. On such findings to mitigate Legionella in hospitals, nursing homes, and other healthcare facilities. So another task force is required to be created, which to study assisted living services, agencies that provide services to individuals living with dementia through a special care unit or program. This task force will be studying on the current regulation of these agencies by TPH, and whether additional oversight is required, whether DPH should set minimum staffing levels for assisted living services facilities, and the maintenance of records by the agencies of meals served to bathing of and administration of medication. This task force is going to consist of eight members who are going to be appointed by various General Assembly leaders. Slide. So next, this requires the long-term care ombudsman to appoint and convene a working group that's going to consist of 8 members to study issues relevant to managed residential communities that are not affiliated with continuing care retirement communities. It's important to note that this working group is actually going to consist of Leading Age, the Connecticut Assisted Living Association, the Association of Healthcare Facilities, and Center for Assisted Living. This working group is going to first convene. This working group was required to convene 60 days after enactment, and they will have a report due on December 31st of this year. And lastly, we have here the sections requiring DPH to work with DSS to establish a working group on emergency medical services. The issues that they will be covering are Medicaid and private commercial EMS rates, the EMS workforce, and mobile integrated healthcare, and looking at that as compared to other states. I think one of the things that's noteworthy here as well is that they're going to be required to issue a report that's going to be covering whether or not there's the methods are being sustainable. They've created an effective and sustainable emergency medical services system over a long period of time. Sorry. Slide.
I think that's we now came to the end of the legislative summary portion. Are there any questions in the chat or other questions for anything that Jermaine just covered?
I don't see any questions in the chat, but does anybody have a question? Please feel free to unmute and ask your question. Well, doesn't seem to be any additional questions. So Maureen, Jermaine, Caroline, thank you so much for that presentation of the outcomes of the legislative session. As Maureen said, we are going to move into an overview of the CON process that was modified this session. That will be something that the nursing homes and residential care homes may be interested in, as they would be subject to CON for various reasons. I'm going to thank our presenters, stop the recording, and then we'll move directly, restart recording again and move directly into our CON presentation if there are no other questions. All right, then. Thank you, Maureen. As I said in the chat, there is the link to the both the full summary prepared by Wiggin and Dana, and also to these slides from this presentation. So if you link on that document in the chat, you will get access to both documents. So thank you. I'm just going to end the recording.